feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go.
In this video I go over Betty's filing on August 15, 2023. This filing is submitted to the courts by Bullhorn Betty. This filing is 9 pages with emails. This is part 3 of the documents filed by Betty. I am going over the documents. The views of Betty are not my own.
Motion to strike Queen's notice and demand for bill of particulars comes now. Plaintiff, Bullhorn Betty, pro se, under Illinois Rule 735 ILCS 52-615, requests this honorable court to strike QueenBee's notice and demand for bill of particulars and states as follows. Background: on or about June 21, 2023, Betty served Queen with a complaint alleging defamation, tortious interference with prospective economic advantage, and intentional infliction of emotional distress. Betty has alleged, among other issues, that Queen has conspired and communicated with others through private chats, such as Discord and other similar sites, to elicit help with Queen's campaign of harassment, cyberstalking, bullying, and intimidation to receive financial compensation, to damage Betty personally, professionally, and financially in an effort to remove Betty from the YouTube platform. On or about July 21, 2023, Queen filed a QueenBee's notice and demand for bill of particulars, notice and demand, and served those upon Betty. The notice and demand are littered with incoherent chatter about tabloid articles that do not promote Betty in a favorable light but fail to connect or indicate how those allegations have anything to do with what Queen believes the deficiencies are in Betty's complaint. Argument: according to Illinois Rule 735 ILCS 52-615, all objections to pleadings shall be raised by motion. The motion shall point out specifically the defects complained of, and shall ask for appropriate relief, such as that a pleading or portion thereof be stricken because substantially insufficient in law. Village of Pawnee v. Nostman, 1983. Under the Rules of Civil Procedure, a party is entitled to a bill of particulars when the complaint it is asked to respond to is wanting in details. The effect of a bill of particulars is to limit and restrict the pleader to proof of the particular cause of action or defense mentioned therein. Hemingway v. Skinner Engineering Company, 1969. If the party on whom a demand for a bill of particulars has been made believes that the party demanding it is not entitled to the particulars asked for, he may move the court that the demand be denied or modified. Village of Pawnee v. Nostman, 1983. Here, Queen's notice and demand for bill of particular, notice and demand, are nonsense and littered with foolish insolent talk designed to distract from the issues at hand. Queen seems to conclude Betty must prove the entire case when filing the complaint against Queen. However, Betty's complaint must contain certain information under Illinois Rule 735 ILCS 52201. The complaint must contain who the parties are, and advise the court and opposing parties of the plaintiff's cause of action. The complaint must use clear and concise language, and contain a prayer for relief. Betty affirms she has met the criteria required by applicable law. Queen has included in Queen's notice and demand an author's opinion from a Vanity Fair article. Betty was not contacted before this article was written nor has ever spoken with the author of said article. The article neither indicates why the author came to the conclusion the author did nor the type of material or materials the author referred to when rendering the author's opinion about Betty, other than the author was displeased with a single thumbnail on a video posted on Betty's YouTube channel. However, Betty is still confused about the relevance that said article has in these proceedings. Betty contends the nonsense has no relevance, is immaterial to the case at hand, and is a poor attempt to introduce inadmissible and damaging information with no good purpose other than to continue the campaign of harassment, defamation, and additional infliction of emotional distress through improper mechanisms such as this notice and demand. Moreover, the material asserted is inadmissible and or irrelevant at trial because Queen has no avenue to authenticate the article, call the author as a witness at trial on Queen's behalf, or against Betty. Betty maintains that Betty has had no contact with the author of the Vanity Fair article. Most of the language throughout this notice and demand, a responsive pleading, appeared to be more of insults, affirmative defenses, or justification asserted by Queen rather than a notice or demand for anything from Betty. Betty further expresses that it has no relevance other than to continue Queen's campaign of harassment, defamation, and for Queen to endure additional intentional infliction of emotional distress, which is the subject of this lawsuit. Betty could also assert articles that are unfavorable to Queen and or promote Queen in an unfavorable light. It is inappropriate, irrelevant and immaterial for purposes of the allegations set forth in Betty's complaint. Betty does not contend any of the information contained in the introduction of the notice and demand as true, but Betty further states even if true, has no relevance to the matter at hand and does not contain a nexus from the statement contained in the introduction to the unclear issues or defects raised in the notice and demand. To address the second article that could not be verified or authenticated by and is therefore irrelevant and or hearsay among other challenges. Either way, Betty contends she has never filed a frivolous suit or has had action, sanctions, verbal reprimand, or any other penalty of any kind for any wrongdoing in a court proceeding. Further, Betty voluntarily dismissed the case for certain reasons inadmissible for these proceeding, and Queen has no knowledge of whether there was an out-of-court settlement, confidentiality agreement, or any other information related to this action other than newspaper articles which are irrelevant and immaterial to the issues at hand and leaves Betty confused. It appears Queen is raising other claims on behalf of other individuals not included or made a part of this action. Queen has no rights or authority to raise or assert claims on behalf of any other individual or individuals except in certain circumstances which usually involve a fiduciary duty on behalf of another person or other reasons. Betty contends that Queen has no authority to raise claims on behalf of any other individuals indicated in the notice and demand. Queen states she is unable to understand what Betty's grievances are. Betty has gone to great lengths to provide concise language and an abundance of exhibits to support the legitimate claims asserted therein. This was done in good faith, so there is no unfair surprise. Betty has the burden of proof. As such, Betty has the burden of proving her case in a court of law. Queen is entitled to discovery in this matter. Betty understands that Illinois courts historically disfavor motions to strike Custom Vehicles Incorporated v. Forest River Incorporated, 2006. However, Betty prays this court will observe the intentional, malicious, and prejudicial actions of Queen and find this is an appropriate remedy. Other issues raised in the notice and demand. Lastly, to address the conclusion in said notice and demand, Mr. Lawyer intentionally and willfully misrepresented facts to this honorable court, when Mr. Lawyer expressed to this honorable court, as an officer of this court, that Betty demanded that Mr. Lawyer cease communication with her, which is categorically false, and Betty prays this honorable court takes notice of Mr. Lawyer's willful misrepresentations to this court, especially in further and future proceedings related to this matter. Mr. Lawyer was not attempting to engage or confer with Betty in a dignified manner. Mr. Lawyer sent an intimidating letter to Betty to demand Betty drop the action against Queen. In good faith, Betty reached out to Mr. Lawyer by email to express that the letter was not well taken and politely told him Betty would not drop the lawsuit and that the statements disclosed in the letter were more untrue statements by Mr. Lawyer's client, Queen. His response was again unprofessional and did not display proper or professional decorum. It was clear Mr. Lawyer had no intention of conferring with Betty. Mr. Lawyer insisted on slinging insults and was verbally combative for no good reason and not in the interest of the preservation of judicial resources and acting in bad faith. Betty does not have to consult with opposing counsel when the opposing counsel cannot even conduct himself in a professional or dignified manner. Please see attached Exhibit A. Betty believes this honorable court will also conclude Mr. Lawyer's demeanor is not one that was professional or something Betty should have to subject herself to when dealing with a licensed attorney. Betty is happy to work with opposing counsel for meaningful resolution only if Mr. Lawyer intends to conduct himself in a professional and ethical manner. This is not the first time Mr. Lawyer has had issues and or misrepresented details in one of his clients' cases. Although Mr. Lawyer was not sanctioned, Mr. Lawyer's clients were. Please see Malibu Media, LLC v. Toshiro, May 18, 2015. Based on the above events, plaintiff contends that defendants and their counsel intentionally misrepresented the number of hard drives in their household in their discovery responses and in their communications with plaintiff's counsel. Plaintiff argues that this constitutes perjury and that default is the only appropriate sanction for the alleged misconduct. The court referred plaintiff's motion for sanctions to the undersigned magistrate judge for proposed findings and recommendations, and the magistrate judge set the matter for an evidentiary hearing on January 29, 2015. On the morning of the hearing, however, Attorney Lawyer advised the court that defendant Charles planned to invoke his Fifth Amendment rights to avoid testifying. Lawyer concluded that this created a conflict of interest between defendants Charles and Kelly, and Lawyer committed to withdrawing as counsel for Charles. Moreover, Mr. Lawyer included in the intimidating letter, none of the foregoing will be looked kindly upon by the judges of the Ninth Judicial Circuit of Illinois. I have no doubt they will, being in receipt of this information, have no issue with awarding fees for a frivolous suit filed for improper purposes. Betty affirms that Queen has not paid for her attorney fees and is rendering payment to Mr. Lawyer by eliciting donations through PayPal, and therefore Betty cannot be held liable for the damage of attorney fees which do not exist. The first campaign was for $6,000 and the second campaign was for $10,000. At this moment, the first campaign ended and is no longer active. Queen raised more donations than requested from Queen's donors, and her second campaign is active and ongoing as she is currently eliciting donations from her donors as of the date of this filing. Betty further agrees this motion to strike does not bar defendant, Queen, from raising a more concise bill of particulars, but believes the current notice and demand for bill of particulars are improper in its entirety and must be stricken for the above stated reasons. Now, therefore, plaintiff, Bullhorn Betty, requests this court to strike defendant, QueenBee's notice and demand for bill of particulars. Respectfully submitted, by, Bullhorn Betty pro se plaintiff. Certificate of service undersigned certifies and states that on August 15, 2023, plaintiff caused the foregoing document to be filed using the Odyssey e-filing system. That same plaintiff caused a copy of the same to be served as indicated below. QueenBee's lawyer and heels in the air.
Exhibit A. Dear Bullhorn Betty, I represent QueenBee as it relates to your lawsuit against her. This letter serves as our demand that you immediately dismiss our client from the suit. If you fail to do so, and my client is forced to incur any fees in defending herself from factually inaccurate and legally frivolous complaint, then we will seek a fee recovery under the Illinois Supreme Court rules and reserve the right counterclaims, including for abuse of process. We strongly recommend you consult counsel. No doubt, you may find this letter to be quite aggressive. Given your past behavior, I expect this may not faze you. But, frankly, it is not my usual modus operandi to engage in strongly worded letters. However, though my investigation of the situation, I have become aware that you filed boilerplate complaints, repeating the same or similar allegations against others. You have been quoted as stating you file lawsuits simply to drive people crazy. I have also become aware through inspection of metadata that others participated in the preparation of your complaints, almost certainly the unauthorized practice of law. Finally, I am aware of your colleagues stating that you know you cannot win your suits, but you file them to simply cause financial pain for your targets. None of the foregoing will be looked kindly upon by judges of the Ninth Judicial Circuit of Illinois. I have no doubt they will, being in receipt of this information, have no issue awarding fees for a frivolous suit filed for improper purposes. If you do not abandon this foolhardy endeavor, we will successfully defend this claim and seek a fee award from you. You have until end of day on July 18, 2023 to file a notice of dismissal and secure an order dismissing our client. If not, we will proceed accordingly. You will find an evidence preservation demand attached. Sincerely, QueenBee's lawyer.
Dear Mr. Lawyer, first, I found your demand letter very insulting and lacking great facts. Second, I find it hard to believe an attorney would initially try and intimidate me through a demand letter. Your information is very much incorrect. There have been 2 lawsuits, both of which I prevailed on. I don't take the act of suing someone lightly. I have repeatedly told her to stop. She continues to lie about me. Even your demand letter is defaming and untrue. Have her give you all those lawsuits I've filed. No, I will not drop the lawsuit. Have a great day. Respectfully yours, Bullhorn Betty.
Ms. Betty, I received your email. While I disagree with your conclusions, we note your intention to persist and will proceed accordingly. As for the letter, and to prevent a misunderstanding causing you to file another suit, please note that under Illinois law, defamation requires publication to a third party. Even if the letter's contents were untrue, and were not subject to the litigation privilege, then it still was sent only to you. Thus there is no basis for a claim. QueenBee's lawyer.
Mr. Lawyer, your professionalism is disgusting. My concern would not be a lawsuit filed against you, but rather a complaint. I am almost certain you compare my channel and what I've said to your client. My case is in good standing. I understand the elements, I've expressed the elements in my complaint, and provided the evidence to support those proper and legitimate claims. If you were going to write me to continue to harass me on her behalf, you've got a big problem, and I'd be more concerned about other more formal repercussions than you would be a lawsuit from me. I'm unsure what your client has told you about me, but I will not allow you to continue her harassment upon me through emails because you're her attorney. Furthermore, if this level of harassment continues from your office, I will be filling your demand letter in the court for the judge to take judicial notice of. Now, if you would like to speak to me and address me with some professionalism, I am happy to work with you on this matter, as I am opposing counsel by way of me representing myself. Again, I have stated legitimate claims and I have met the elements of those claims. And since it appears that you do not wish to work with me, I'm going to demand you discontinue communication with me until we are before the judge to discuss this very matter. Respectfully yours, Bullhorn Betty.
Ms. Bullhorn Betty, we note your request that we discontinue communication with you. We will honor your request. However, please note that we will, of course, still serve you with filing as required by applicable rules and law. Sincerely, QueenBee's lawyer.
Thank you for your response. Respectfully yours, Bullhorn Betty. Lastly, I want to let you know when I initially responded to your letter that the defaming and untrue statements I was referring to are those of your clients, not of you. I was expressing that she's even lying to you about the information about me, and it was clear in your demand letter. So the insulting response from you was not well taken.
First, I want to remind everyone that I am not a lawyer, and I do not claim to be one. In my opinion, Betty has given false information to the courts and provided the proof of her false information. Betty stated she never told Queen's lawyer not to contact her anymore. Betty provided the emails where she demands the lawyer not contact her. Betty also has an issue how Queen paid for her legal fees. In my opinion, it does not matter how the lawyer was paid. The money was still paid to the lawyer. She cannot dictate how the funds were collected. What are your thoughts? Let me know in the comments section below.